part 2 of our asynchronous class. In this class, we're going to talk about one of the most important cases that we'll be reading this semester, the Vermont Yankee case. Most cases that we read in this class, I've picked because they're good examples, not because they're important cases in and of themselves. Vermont Yankee is different. Vermont Yankee is a case that you should know the name of, because Vermont Yankee, just saying that, is shorthand for the entire doctrine that flows from it. The same is true of Florida East Coast Railway, the case that we talked about in the first video, and I should have said that. So unlike the environmental integrity case, which I picked because it was a good example, Vermont Yankee and Florida East Coast Railway are cases that define the category of environmental law. If you bring a challenge to an agency rulemaking, you will be grappling with these cases. With that preface, let's look at the Vermont Yankee facility. Here it is. This is what it looks like. This is the reactor that is in Vermont, hence the name Vermont Yankee. As you can see, it is directly adjacent to water. Nuclear power plants need a lot of water for their cooling systems. You can see from the case that the court here is interpreting the section of the APA that we read for class last time, section 553. In particular, the court is focusing on the principle that after notice, the agency shall give interested persons an opportunity to participate in rulemaking through submission of written data, views, or arguments, with or without the opportunity for oral presentation. And here's just a hint in reading a case. When the court said that the Court of Appeals has seriously misread or misapplied the statutory and decisional law, that's a pretty big deal. So here, the court is addressing what does section 553 mean, and is taking down the lower courts for their interpretation. You can see that the Supreme Court is pretty annoyed with the lower court. Let's start by looking at how the court in Vermont Yankee describes what it did in Florida East Coast. The court says, "We held that generally speaking, section 553 established the maximum procedural requirements which Congress was willing to impose upon agencies in conducting rulemaking procedures." So the court frames this in separation of powers terms. It describes the APA as Congress's statement about agencies, which is, of course, mandatory because agencies are exercising authority that Congress has given. And then notes that agencies can add additional procedures when in their discretion it's going to improve the decision, but that courts can't add procedure. So we have all three branches here. Congress set procedures that agencies must follow. The agencies, which are part of the executive branch, in carrying out their duty to take care that the law be faithfully executed, can add additional procedures when they think those procedures will be useful. But courts, in reviewing agency decisions, are not free to add procedures. That's the important point of this case. Now, I would just point out, if you reread Florida East Coast Railway, the court doesn't say that anywhere. So as the court is characterizing what it did in Florida East Coast Railway, in this case, Vermont Yankee, right, it is interpreting Florida East Coast Railway rather than quoting, because the court didn't say any of that, especially not the part that's in bold. Here's what the court actually said in Florida East Coast Railway. The court said the term hearing has a host of meanings, and that in interpreting the term hearing in a statute, it is appropriate to refer to the Administrative Procedures Act and what that act does and does not require. Okay, so with that backdrop, let's look at what actually happened in this case. I'm going to give you a quick overview of the timeline so you can understand what's going on, because the case itself refers to adjudications and rulemakings, and it can be a little difficult to sort them out. First of all, you should know that the agency that's at issue in this case, the Atomic Energy Commission, doesn't exist anymore. The Atomic Energy Commission was abolished in the early 1970s, or I guess the mid-1970s, 1974, and the Nuclear Regulatory Commission was created to take its place. One of the main reasons that Congress abolished the Atomic Energy Commission was over concerns that its regulations were insufficiently rigorous. At the same time, we have a parallel political and legislative process playing out to address perceived inadequacies of the Atomic Energy Commission. Anyway, in the 1960s, Vermont Yankee applied to build a nuclear power plant. They got a license to build the plant. But then Congress, in 1969, passed NEPA, the National Environmental Policy Act, which required environmental review of every major federal action, including licensing nuclear power plants. The process of licensing a nuclear power plant is twofold. You need a license to build the plant, and then you need a separate license to operate the plant. After the plant was built, when they came back to the Atomic Energy Commission to get an operating license, the NRDC, the Natural Resources Defense Council, which had actually just been formed, intervened and objected to the operating license. At the hearing that was held about whether or not to issue this license, and remember, a license is an adjudication, right? It's a hearing that is specific to a particular actor and focuses on particular concern. At that hearing, the Atomic Energy Commission decided they didn't need to think about environmental effects of nuclear waste in issuing the license. Much like the issue that we talked about in the environmental integrity case, the AEC realized that this was an issue that was going to recur over and over and over again in every license. How should we consider environmental effects of wastes in issuing licenses? So they decided to engage in a rulemaking and to make a rule, realizing that this was an issue that was going to recur in every licensing for every nuclear facility. And remember, at this point in time, the United States is ramping up its licensing of facilities and its reliance on nuclear energy. This was before 3 Mile Island. This was before the public concerns about nuclear energy really got traction. Given that the agency expected to face this question of what will be the environmental effects of nuclear waste and how should that be considered in the licensing decision, they were expecting to deal with that in every licensing. They decided to make a rule about it. So they held a rulemaking hearing to decide how to consider it. And it's this rulemaking that is the subject of the litigation. Now, the key part of the case, there are many, many challenges. But the case that we read, we only read part of it, and the part that we read focuses on the administrative procedures. Right now, in this rulemaking, the Atomic Energy Commission did not allow discovery. They did not allow NRDC, who had intervened in the licensing below, they did not allow them to conduct discovery, nor did they allow them to conduct cross-examination. They did, however, have a public hearing, at which point NRDC, like anybody else who was interested, got to say their couple of minutes. After that, the Atomic Energy Commission issued the rule, and it's that rule that is the subject of this lawsuit. So NRDC brings a lawsuit challenging this rulemaking. Their argument really hinges on their ability to cross-examine a particular witness. As part of the rulemaking, the Atomic Energy Commission relies on an internal scientist, Dr. Pittman, who offers them an opinion paper saying that there are no environmental concerns that need to be taken into account in licensing with regard to nuclear waste. NRDC argues that the agency should have given them the opportunity to cross-examine Dr. Pittman. The problem they run into is that this is unquestionably not a formal rulemaking under Section 556. They're not contending that it is. What they argue instead is that Section 553 establishes a minimum of process, and that courts can, in their judgment, require more process when they think it's in the interest of justice or when it's involving complex and technical issues or issues of great importance. And the court quotes that and puts it in all caps to show you what they think of that particular contention. attention. So they persuade the court below, the DC Circuit, which views its task as deciding whether or not the procedures that the agency used were sufficient to ventilate the issues. So the DC Circuit is not assessing whether or not the agency complied with Section 553. They've created a different question for themselves, which is, was the agency's process adequate in light of the questions before the agency? And that's what sends the Supreme Court ballistic. The Supreme Court frames this as a separation of powers question as to who has the power to decide what procedures will be used. The Supreme Court emphasizes that 553 is the maximum, not a minimum, but the maximum procedures that are mandatory on agencies, and that absent constitutional constraints, it's up to the agencies and not the courts to decide what procedures are appropriate. So agencies are free to add additional procedures, but the court is not free to require that agencies add additional procedures. This is a very specific vision of what the court's jurisdiction is over agency decision-making. And so long as an agency has complied with the APA, then courts will not second-guess the agency's choice of procedures. So judicial review is limited. Right? Judicial review is limited to assessing whether or not the agency provided the procedures specified in the APA. In Florida East Coast Railway, the question was whether or not the procedures specified in the APA were formal procedures or informal rulemaking. Right? The question there was what procedures were required in light of the language in the organic statute. Here the question is a little bit different. The question is, given that this is governed by Section 553, what procedures can be required of the agency? So it's the next logical question. So Florida East Coast Railway answers the question, when are formal procedures required under the APA? This case says, when formal procedures are not required, what can courts ask of agencies? What can courts demand of agencies? Now, the court identifies a number of concerns that motivated this decision. First, the court complains about the idea of Monday morning quarterback, the idea that the Court of Appeals was using hindsight at the end of the process to decide what procedures the agency should have offered at the beginning of the process. And that's a no-win situation for the agency because they can't possibly know at the beginning of the process what they know at the end of the process. So the court says that's an unfair standard. The court is also concerned about the idea of ossification. Ossification literally means turning to bone. And in the context of administrative law, ossification is the freezing of administrative process, of slowing it down and turning it to bone, making it impossible to move forward, depriving it of flexibility, etc. And the court says that when it says, if the agency is compelled to support the rule which it ultimately adopts with the type of record produced only after a full adjudicatory hearing, it simply will have no choice but to conduct a full adjudicatory hearing prior to promulgating every rule. And the court is concerned that procedure upon procedure, many of which are not appropriate in the court's mind for rulemaking, things like evidentiary hearings, will make rulemaking impossible. And then we were also talking earlier about separation of powers and how much the court is emphasizing who has the power to make what decisions about the rulemaking process. Congress initially has the power to set the procedures that the agency must follow, both through the Administrative Procedures Act laying out procedures and through the language of the organic statute, which can specify additional procedures if Congress chooses. Once Congress has made that choice, the agency is bound by whatever Congress directed it to do, and can, in its own judgment, add procedures in the interest of carrying out its mandate. Courts, on the other hand, are really policing the boundaries. They are making sure that whatever the APA and whatever the statute, the organic statute requires, has been provided. But they are not doing more. They are not using independent judgment to decide what procedures might be helpful. Now notice, this case does nothing to jeopardize the logical outgrowth. The two can coexist perfectly fine, because the logical outgrowth rule is a court asking, did the agency comply with the APA? Not did the agency provide the best process that would make the most sense, right? That's what the Court of Appeals did in Vermont Yankee, and they got their head handed to them by the Supreme Court. But the logical outgrowth test of did the agency comply with the statutory requirements still is perfectly fine. As we've been talking about rulemaking, here are the questions to ask. First of all, did the agency make a rule? Right? Section 553 only applies to rulemaking. If the agency did not make a rule, then none of this is relevant. Second of all, did the agency use notice and comment? Was it done properly? Is it the final outgrowth of the proposed rule? Did the agency respond to comments? Did the agency provide all required procedures? Those are the questions you ask when you assess the procedural validity of an agency decision. And then there are other questions I want to highlight for you because I want to keep them in the back of your mind. And those are other ways to challenge an agency's decision. Was the agency arbitrary and capricious? Did the agency exceed its statutory mandate, its substantive mandate? Because environmental law is my thing, I want to give you just a little bit of detail about what the fight was about in this. So they had a hearing for this rule, and Dr. Pittman, as I said, he was the AEC expert. He testified that the environmental effect of spent fuel rods would be so slight that they didn't need to worry about it. It could be disregarded because spent nuclear fuel would be reprocessed, and the federal government would construct a storage facility for storing spent nuclear fuel rods. Just for the record, we still haven't done that. We're still fighting over where to locate a storage facility because, strangely enough, nobody wants it near them. Dr. Pittman offered very little in terms of details about what would happen if there were a failure of the cooling system. In particular, he said that environmental concerns were a bugaboo and that the possibility of a meltdown was incredible because it would take over a week for the cooling water to boil away, allowing various corrective actions to be taken. That was his testimony at the rule-making hearing. What NRDC wanted to ask him was exactly that. What happens to this facility, to this Vermont Yankee facility, but to any facility, if they lost power and they lost backup power and nobody could get there to fix it within a week, what would happen? Well, we now know what would happen because it happened in 2011 in Fukushima. This is a picture of Fukushima. I don't know how much you folks remember it, but in 2011, there was a tsunami that destroyed the facility, compromised the nuclear power plant, and cut out the power and the backup power, and it took too long to try to fix it because they couldn't, because there'd just been a massive natural disaster, and because the facility was compromised and there were radiation leaks. So what happened was exactly the situation that NRDC wanted to question Dr. Pittman about. I tell you that just because it's easy when you read these procedural cases to forget that they have real-world consequences. And in this case, the real-world consequences of the court's decision that federal courts could not require additional procedures besides those in the Administrative Procedures Act or the organic statute meant that the Atomic Energy Commission never had on the record what would happen if the power and the backup power were cut and people could not get to the facility to take the corrective actions that Dr. Pittman so airily suggested. And we're still grappling with the ramifications of Fukushima. I should add that the Fukushima plant was the kind of plant that was at issue in Vermont Yankee. And we'll just end by talking about the fate of the Vermont Yankee plant. In 2014, the Vermont Yankee plant announced that it was going to shut down. The world had changed. There was no longer really an interest in the power from this plant. It was too expensive. Nuclear power tends to be very expensive. The local resistance to the plant was immense. Vermont didn't want it to be relicensed, and the company eventually threw in the towel and shuttered the plant.